Friends, Namaskar. In today's video, we will deal with yet another important aspect pertaining to the inquiry report being submitted by the inquiry officer. Dear friends, in the last video, we have discussed, and let me recap for a moment, that when inquiry report is submitted by the inquiry officer holding that the charges are proved against the charge sheeted employee, the charge sheeted employee is entitled to receive such a report so that he can make a representation against such a report, point out as to what are the defects, whether evidence is properly appreciated, whether the finding is recorded without being supported by the evidence on record, whether there is appreciation of the evidence in proper perspective, etc., etc. And after reply or representation to such inquiry report is received, the disciplinary authority will consider the report as well as such a representation and proceed ahead. So this was what we have discussed in the last video. Today, dear friends, I am dealing with yet another important aspect pertaining to inquiry report, but slightly different. So in this case, today we will deal with a circumstance. Let us take a case. Let us imagine it is not necessary that in every inquiry the inquiry officer will submit a report holding that charges are proved. In a given case, when the inquiry officer himself, after conclusion of the inquiry proceedings, comes to a conclusion and records a finding that charges are not proved, that means he is giving a clean sheet to the charge sheeted employee. That means he is exonerating the charge sheeted employee because he feels that there is no evidence to hold or to prove that charges are proved, and still such a report has to be submitted to the disciplinary authority who has appointed inquiry officer. Now this is slightly different from earlier circumstance where charges are held proved. Now it may happen, and it happens in fact, that the disciplinary authority may disagree with such a report and hold that the charges are proved after the appreciation of the evidence on his own and going through the material on the record and hold that charges are proved. Now as we have discussed in the last video, that the report in which charges are held proved is necessarily and mandatorily to be given to the charge sheeted employee. Now in this case today, where the report is exonerating the employee concerned, but the disciplinary authority himself is disagreeing with such a report and proposing to impose the penalty, what is the law on this aspect? What is the principle of natural justice entering into picture? Now before I deal with this issue, let me discuss a very famous and well-known case law, that is precedent coming from our Supreme Court. In the case of Yoginath Bagde versus State of Maharashtra, this very issue arose before the Supreme Court of India. In this case, what had happened was that the charge sheeted employee happened to be a judicial officer holding the rank of additional district judge and session judge. He was charge sheeted on the charge that he demanded bribery to help some accused, and then ACB trap was laid, but it failed. But despite that failure of the ACB charge, he was charge sheeted in the departmental inquiry, and the inquiry proceedings ended with the report of inquiry officer holding that charges are not proved. That means this judicial officer was given a clean sheet by the inquiry officer's report. However, the disciplinary authority did not agree with such a report and proceeded to impose the penalty upon that judicial officer, and this judicial officer was dismissed from service. He appealed against that in the High Court, failed. Upon failure in the High Court, he went to Supreme Court and there he succeeded. Now in that, while dealing with this case, Supreme Court of India has explained that Article 311(2), that is subclause 2, incorporates principles of natural justice, and it talks about the opportunity of being heard, the right of being heard, and this right of being heard continues to be there till the conclusion of the inquiry proceedings, because the report of inquiry officer itself is not an end, or it does not bring an end to the inquiry proceedings. It only brings an end to the first stage. An actual end of the inquiry proceeding is the imposition of the penalty by the disciplinary authority, and therefore this right of being heard continues till the inquiry proceeding is there. Under such circumstances, Supreme Court says, when the report in which charges are held proved has to be given to the employee concerned, then it is all the more necessary to give such a report in which charges are held not proved, but the disciplinary authority is disagreeing with such a report and then proposing to impose the penalty upon such a charge sheeted employee. Here, Supreme Court says that the employee concerned who has been given a clean sheet by the inquiry officer's report is entitled to receive the report of inquiry officer along with the tentative reasons recorded by the disciplinary authority, on the basis of which he is disagreeing and proposing to proceed ahead against the concerned employee. What happens in such cases? When the charge sheeted employee is exonerated by the inquiry officer's report, the disciplinary authority disagrees with the report and holds that there is enough material to hold that charges are proved and to punish him, and then proceeds to issue a show cause notice calling upon the charge sheeted employee as to why the penalty should not be imposed for so and so reasons. Okay. Now here consider one aspect. The disciplinary authority is in fact preparing another report like inquiry officer report in which charges are held proved, and then on that basis he is proposing to impose the penalty and therefore calling upon the charge sheeted employee. Now here it is very important, crucial aspect where Supreme Court of India has laid down that the inquiry officer's report plus the tentative reasons, the reasons should not be conclusive and final. The disciplinary authority, upon receiving of the report in which charges are not held proved, should record the tentative reasons, and then he should forward the report along with his tentative reasons, that is called note of disagreement, and then these two things will have to be given to the employee concerned, so that the employee concerned will make a representation against the note of disagreement as well as the tentative reasons, and will say that the findings recorded by the inquiry officer need not be interfered with or need not be reversed by the disciplinary authority. And Supreme Court has gone to say that such a right, being the constitutional right, cannot be taken away even by the rules, framed by the government, even by the rules framed under Article 309 of the Indian Constitution, which gives powers to the government to frame the rules or the service rules. Now this being the principle of natural justice, if it is violated, as we have seen in the last video, the violation of principles of natural justice results into violating Article 14 of Indian Constitution, as held by Supreme Court in the case of Tulsiram Patel versus Union of India. And when there is a violation of Article 14, again it results into violation of Article 21, as held by Supreme Court in the case of Maneka Gandhi, to the effect that violation of Article 14 is automatic violation of Article 21. Therefore, when the employee concerned is punished even when he is exonerated by the inquiry officer by the report, and then without abiding by such a procedure as laid down by Supreme Court in the case of Yoginath Bagde, that is giving tentative reasons of disagreement along with the report to the employee, if this is not followed, it will result into violating not only principle of natural justice but fundamental right under Article 14 and also Article 21, and on this ground alone the inquiry proceeding is bound to be set aside. The penalties in such inquiry are also bound to be set aside, and this being very vital aspect of departmental inquiry procedure, it cannot be even otherwise taken away by the government by framing different rules than what Supreme Court has explained in this case. And dear friends, if you come across with any such departmental inquiry where this kind of procedure is not adhered to or not followed or abided by, you can raise this ground in the tribunal or the court concerned and successfully defend your case and get the penalty set aside in the court. Now dear friends, with this short video I will stop here, and please don't forget to leave your comments in the comment box giving suggestions so that we can consider those suggestions in the next video, and we will try to enhance the quality, increase the quality of our videos. And please also do not forget to subscribe to this channel and to share the video if you like. Dhanyavad.